I wanted to begin this evening by acknowledging and celebrating the first Australians on whose traditional lands we are digitally meeting today, and pay my respects to their elders, past and present. This webinar series is part of a continuing program that the ANU College of Law Centre for International and Public Law, in conjunction with the Australian New Zealand Society of International Law, is running throughout 2022. 2022 is, of course, the year in which we will eventually celebrate the 40th anniversary of the conclusion of the 1982 UN Convention on the Law of the Sea on the 10th of December this year. And CIPL and ANZSIL thought that this was a wonderful opportunity to hold a series of webinars over the course of 2022 with two aims. One was to reflect on the negotiation of the Law of the Sea Convention, and also to reflect upon its achievements. And that's principally the objective of this webinar series. But then as we move towards the end of the year and the 40th anniversary itself, to actually hold an event looking forward beyond 2022 in terms of the next few decades of the Law of the Sea Convention, asking questions as to whether or not the convention is fit for purpose, what adjustments and modifications might need to be met, and what challenges the Law of the Sea faces into the future. Our first webinar in February focused on Australian and New Zealand perspectives to these questions. And this evening, I'm delighted to say that we're focusing on Pacific perspectives on these issues. And we have a very distinguished panel of speakers to give us their perspectives on those questions. Before I commence though, I just wanted to formally acknowledge the contribution of someone who sadly has left us, but who has a strong connection with the Australian National University and the Law of the Sea in the Pacific. And I'm referring to Bill Edison, who many of you would know of. Bill was a long-standing academic, a long-standing practitioner, and an international official on Law of the Sea matters over many decades, up until his untimely death in October of last year. Bill served as a member of the academic staff at the ANU College of Law between 1975 and 1988. And indeed, just last week, I had occasion to revisit some of Bill's early work on historic bays in Australia that he wrote about in the Australian Yearbook of International Law. Many of you will be familiar with Bill's work at the FAO, and then more recently in the latter part of his career in the South Pacific. The Pacific Islands Forum Fisheries Agency has published a beautiful tribute to Bill on its website that you can find there. And also colleagues at the International Journal of Marine and Coastal Law have also written very movingly of Bill's contribution to the law of the sea and maritime affairs globally. So if I can acknowledge Bill's contribution and say that he's in our memory this evening. So I'm now going to hand over to my colleague, Dr. Camille Goodman, from the University of Wollongong, from ANCORS at Wollongong, who for the purposes of this webinar is representing the Australian New Zealand Society of International Law. Camille, welcome, and over to you.
Thanks very much, Don, and welcome everybody. It's wonderful to have so many people joining us for the second webinar in this series on Pacific perspectives on Law of the Sea. This is a topic that's really close to my heart, so I'm grateful to Don for inviting me to moderate this discussion. Now, tonight, we are privileged to be joined by some world-class experts on law of the sea. We have here with us Judge Neroni Slade from Samoa and Professor Transform Aqorau from the Solomon Islands. And hopefully we'll also have joining us Dr. Manumatavai Tupou-Roosen from Tonga. Now, these speakers have enormous experience and expertise in the law of the sea, and in different and innovative ways, they've played a critical role in developing and implementing it in the Pacific and well beyond. You can find links to their many and varied achievements via the biographical details, which Charlene will post in the chat. So instead of providing lengthy introductions, many of them will be well known to you anyway, I want to let these people speak for themselves and maximise our opportunity to hear from them on the Pacific region's approach to and involvement in the negotiations at UNCLOS III, and about the implementation and operation of the Law of the Sea Convention and the challenges and opportunities that it presents for this region. I think many of us feel correctly that Pacific Island states have a uniquely cooperative, collaborative approach to the law of the sea. So I want to start by talking about this Pacific approach in the context of UNCLOS III and the Law of the Sea Convention. And I'd like first to turn to Judge Slade. Judge, you led Samoa's delegation to much of UNCLOS III, and that makes you one of a small and special group of people who can talk authentically about what those negotiations were like. So to set the scene for our discussion, could you perhaps give us a flavour of that experience?
Thank you. Thank you very much indeed, Dr. Goodman. A great honor to be here, and thank you. Grateful for the opportunity. 40 years is half a lifetime. Although for those who took part in the work of the United Nations Seabed Committee from the start, it's probably more like 50 years. But as we only have a few moments to try and gather perspectives on matters so consequential, and in which, in my view, have conditioned our region in so many, many critical ways. Among them, first, I think UNCLOS had triggered the exposure and participation of Pacific Island countries in the workings and the making of international law in this field and in many other critical fields. Secondly, early in the shared experience of Pacific countries, UNCLOS has given impotence to strategic and practical regional cooperation, as forum leaders had directed back in 1971 on this matter of oceans. With the experience gained and the confidence gained from taking part, I think the taking part of critical regional action, like the establishment of the Forum Fisheries Agency in 1979, I think at the initiative of Papua New Guinea and Fiji, in the face of significant opposition from major fishing and maritime powers, and at a time even before the conclusion of UNCLOS, and as Pacific countries had always contended, fully in accordance with international law and principles since made clear and reaffirmed in UNCLOS. I personally view the establishment of the Forum Fisheries Agency as uppermost in the finest of our regional achievements. I believe the UNCLOS work had helped to condition and to initiate essential and related programs and conventions, including the Treaty of Rarotonga in 1985, creating the South Pacific Nuclear Free Zone, the Nomea Convention of 1986 for the protection of natural resources and environment of the region, a convention which gives emphasis to the special hydrological, geological, and ecological characteristics of our region, all of which require special care and responsible management. And the Waigani Convention of 2001 to control the transboundary movement of hazardous wastes in the region, And of course, there are other oceans-related programs now in the work province of the Pacific Ocean Commissioner. The ocean now is the proclaimed common heritage of humankind. But of course, for us here, by its true destiny, the ocean is our home, the living heritage of all Pacific cultures and communities. It is why, and I think correctly so, the law relating to the ocean, unlike any other, has commanded priority attention for all Pacific countries, and in my view, must continue to do so. Madam Facilitator, your reference to my leading the Samoan delegation to UNCLOS is kind, but it's a bit grand. In fact, it was a very small team of just 2 government officials, then relatively young people and without a great deal of experience in law of the sea issues. My colleague, Philip Muller, the government meteorologist at the time, was a trained mathematician, but he was doing research work on tsunamis. So at least he had some ocean-related qualification. Philip was the first director of the FFA, and later on the director of the Pacific Geoscience Commission, or SOPAC. However, the Samoan delegation was twice as large as a single delegate from Tonga. Tevita Tupou, friend and colleague to many of us, now senior law lord of the kingdom, and I think the father of Madam Director General of the FFA. Pacific countries attending the first substantive session of UNCLOS in Caracas in 1974 were Australia, Cook Islands, Fiji, Samoa, and Tonga, later to be joined by Papua New Guinea, not yet an independent country, whose representative, Peter Donigi, was attached to the Australian delegation, and the Federated States of Micronesia, whose representative was attached to the United States delegation. The Premier of the Cook Islands, Sir Albert Henry, as he then was, a renowned Pacific orator, was commanding in his presence and his plenary address. At the time, there was known prospect of manganese nodules off the Cook Islands, and the Premier's concern was to register the position of his country in the conference, in part because the African states had begun to take the view that countries under foreign domination, as I think Angola and Mozambique then were, are not entitled to any economic zone. Why so few Pacific countries in Caracas? Well, because at the time the Seabed Committee in 1970 and the first session in Caracas in 1974 and thereafter, not all Pacific countries had gained independence, and not all of them were members of the United Nations. Samoa, the first island state to gain independence in 1962, did not join the United Nations until 1976. Alongside Australia and New Zealand, only Fiji, independent in 1970 and which had joined the United Nations that year, had participated in the work of the UN Seabed Committee. It meant, of course, that for the rest of the Pacific Island countries, UNCLOS was all new territory, and for small delegations, somewhat of a real struggle to learn and to keep up with the bewildering complexities of the conference. Remember also that what we know today as the Pacific Islands Forum had just been established by leaders of 7 then independent countries: Australia, Cook Islands, Fiji, Nauru, New Zealand, Tonga, and Samoa, or Western Samoa, as it was then known, established at their first meeting in Wellington in 1971. 2 issues were high on the leaders' first agenda: law of the sea and French atmospheric nuclear testing. Both these issues remained of critical concern to the region over the ensuing years. At their second meeting in Canberra in 1972, leaders resolved that Pacific countries should present a united stand at the forthcoming Law of the Sea Conference in Caracas. Just prior to the Caracas negotiations in July 1974, there was a gathering of Pacific countries in Suva for expert representatives of Australia, Fiji, and New Zealand to provide a full briefing on the issues and to consider possible strategic approaches. This, of course, was a very especially crowded time in 1973, 1974 for senior diplomats and lawyers of our region, with proceedings before the International Court of Justice by Australia and New Zealand and Fiji seeking to intervene, the first ever ICJ intervention by any country, I believe, in support against the French atmospheric nuclear testing. Much later, in 1995, with New Zealand's second application against French nuclear testing before the ICJ, Australia, Federated States of Micronesia, Marshall Islands, Solomon Islands, and Samoa sought to intervene in support. All interventions were denied. In its general statement in Caracas, Fiji, on behalf of Pacific delegations, voiced the Pacific's concerns against the French test in Mururoa. To avoid undue distraction from the negotiations, the statement merely drew from the Pacific leaders' communique of their forum meeting in Rarotonga in March of 1974, and it seemed that France was willing to accept that. Now, what was it like to be at UNCLOS III? This, of course, was an event of truly global proportions for the magnitude of the issues at stake and for the attention and priorities devoted to it by the international community and by the United Nations system. It called for ambition and leadership at a political level, as it did for the engagement of talent at the highest levels of diplomacy, academia, law, science, and other professional services in government and in civil society. As a lawyer, one saw the best of minds and performance from all continents around the world, from the large maritime nations as from much smaller nations like those in the Caribbean, and standout delegations like that from Singapore. It's been a matter of privilege for me over the years that one has become friends and colleagues with some of the UNCLOS key players, and a privilege to work with a number of them as United Nations personalities and as judges in The Hague. Thank you very much, Dr. Goodman.
Thank you, Judge. That's an incredibly rich answer to that question. And it really does give us some important perspective on size of delegation and also size of influence, and perhaps outsized influence, given the expertise and ability of some of those people you mentioned. And it's great to reflect on some of the key players from the region. You mentioned Philip Muller, for example, and others. Can I ask you to follow up just briefly? You've written about the style of island state diplomacy. You've talked about its pragmatism and reasonableness and preferring consensus building to obstruction and confrontation. So could you just briefly reflect on how the Pacific approach to diplomacy influenced those negotiations at UNCLOS III, and perhaps highlight a couple of key areas in which that influence was sought to be exerted?
Well, thank you very much. Culturally and generally speaking, I think Pacific people are careful. I think they're socially aware and respectful of others and their claims. And I think these are instinctive elements in their international behavior and dealings. Smallness and the fact of the novelty of Pacific Island participation in the process were significant constraints, and therefore working together as Pacific countries in our Oceania group was pragmatic, indeed necessary. In any event, UNCLOS had been conceived as a package deal, and it was agreed in Caracas with a formal declaration to that end that the conference should take every effort to reach agreement on substantive matters by way of consensus, and there should be no voting on such matters until all efforts at consensus had been exhausted. Cooperating and working together with other like-minded states has, of course, become the international trend in many conferences now. In addition to the Oceania Group, we, the Pacific Islands, also worked as members of the group coastal states, the group of developing countries, the group of 77, and also in the Asia Group. Australia and New Zealand had their own group associations as well. The reality was that these various groups were and are purely interest groups, intent on national or specific goals, such as the coastal states, landlocked countries, geographically disadvantaged ones, and island states, and so on. There were others. And in fact, within each group, there was not always harmony and agreement, and there was not always agreement on every law of the sea issues. And I would have to say that this is exactly what happened in our own Oceania group. We did not always agree on every aspect of detail. That in time, the world community was able to transform so many of these competing national interests and able to distill the work of all these groupings and to agree on a constitution of the oceans as UNCLOS is, must stand as one of the greatest of achievements of the conference, an achievement which says that the international community was able to evolve and to find an agreed global vision for the success of UNCLOS as the real and the overriding objective. That was the objective, not the total achievement of national goals, a great achievement. I believe it also speaks to the committed and the very highly competent and elevated leadership of the conference, people like Ambassador Shirley Emersinghe, Andre Aguilar, and of course the highly esteemed Tommy Coe. What were the key areas of focus? Well, necessarily the Pacific delegations had to focus on the establishment of a broad 200-mile exclusive economic zone, the creation of a 12-mile territorial sea, and critically, the acceptance of the regime of islands, at least our version of it, and more particularly an exclusive fisheries jurisdiction in the zone. As to the regime of islands, I think it was essential that Pacific countries engage in UNCLOS and to be seen and to be heard by the international community. I think this was a great strategic move, and we gathered a lot of sympathy and empathy in our special and unique positions. We worked hard and we worked well in the Oceania group to explain the uniqueness of our Pacific position and our reliance on the oceans and its resources, and to submit carefully balanced and considered text proposals likely to gather wide acceptance, acceptable to other countries, and to gather support for the regime of islands. We took care to respond to the expressed concern of other countries, and there were a number of countries in Europe, Turkey, Greece, Cyprus, Tunisia had a problem with Italy, and what these countries considered problems. Largely, I think they were delimitation problems, particularly if the offshore islands of other neighboring states were able to generate full zones of their own. There would have been severe disadvantages and losses to countries of our region had we in the Oceania group failed in our efforts. especially on such a critical issue as the regime of islands. But now, as you know, as stated in Article 121 of the Convention, islands generate the same territorial sea, exclusive economic zone and continental shelf as any other land territory. We can all be grateful for the efforts by Australia, Fiji, and New Zealand to ensure that as many Pacific countries as possible were able to participate in Carruthers and other sessions of UNCLOS, and for their leadership and assistance to the smaller delegation. If I may, Madam Facilitator, I would leave our expert colleagues to deal with the question of fisheries. All I need to say is that equally we can be satisfied that the Pacific position on fisheries has been recognized under Article 56, Transform. The coastal state has sovereign rights over all living resources of the zone. We in the Samoan delegation, just the two of us, we could only follow the Committee 1 dealing with the area beyond national jurisdiction, and Committee 2, the key one dealing with the regime of islands, the territorial sea, the EE zone, and so on. And we could only attend the work of Committee 3 when we could. What we know today, with what we know today, I should think there would be a lot more focus in a body like Committee 3 on climate impacts and marine pollution from land-based sources. That is my own view. I should note here a perspective I had gained from Tommy Coe. That is that when he was chairing the negotiations at the Rio Earth Summit in 1992, he had included Chapter 17 in Agenda 21 in order, in his words, to harmonize UNCLOS and UNCED. Part of Chapter 17, as you will know, is devoted to small island developing states, which are recognized as a special case for the environment and development. And it is Agenda 21 which provides mandate for both the Barbados Conference on SIDS, which occurred in 1994, and the United Nations Development Program dedicated to SIDS. That's a very special gain for small islands. Equally, its mandate also for the Fish Stocks Agreement, which of course took place in 1995, now an integral part of UNCLOS. Pacific countries participated in good numbers and provided, in my view, valuable and substantive contributions to both these processes. Returning to the Caracas UNCLOS session, this truly was a voyage of discovery for Pacific delegations, with a great deal to catch up with and much to learn. The great Chris Beebe of New Zealand had observed that this was the first real occasion for Pacific lawyers and delegations to participate at this level in a major international conference of such importance, and I thoroughly agree with that. Australia and New Zealand had sent large and high-level delegations, including renowned legal scholars and like Professor Eli Lauterpacht. I'd never heard the Australian delegations speak with such high-toned English voices and terms. Many of them, as Satyanandan of Fiji were important office holders in the conference, but always available to be consulted and to assist the smaller Pacific delegations, and we are grateful to them for that. Thank you very much.
Thank you. And I think a lot of the key initiatives that you've mentioned, they're easily visible now on a map of the Pacific. Those zones stand out so clearly whenever we're looking at it. Professor Aqorau, you've been closely engaged in the implementation of the convention, the Law of the Sea Convention, and other Law of the Sea instruments throughout the Pacific since the 1980s, including through a range of regional institutions. And you've written a lot about this, and particularly about the concept of what you call Pacific regionalism. So could you perhaps talk about the role that Pacific regionalism's played in implementing the Law of the Sea Convention and developing international fisheries law in the Pacific over the last 40 years?
Good evening, everybody, and thank you very much, Dr. Camille, for your kind introduction. I could actually sit here and listen to Neroni all night. Such lovely narration of the rich history of the Law of the Sea Convention. I also count it a great privilege to have worked quite closely with Philip Muller. He was a wonderful, wonderful boss in my early career. I learned so much from Philip. It was a wonderful privilege also to know Manu's dad, Evita Tupou, and also such an Andan who is an inspiration to many of us who work in the field. You're right. I think, as we all know, the Law of the Sea Convention and regionalism, I don't think we could actually implement so much of the obligations that we've assumed. And just discussing with Satya Nandan, he envisages that it was not going to be possible for countries individually to implement the obligations under the Law of the Sea Convention, and therefore the decision by the Forum to establish the FFA in 1979 was pivotal in the exercise of the aspirations of Pacific Island countries to gain economic benefits from the Law of the Sea Convention, from the exclusive economic regime in particular. So if you look at all the implementation of the convention conservation measures through the FFA, it's all through, it's been coordinated, the development of harmonized minimum terms and conditions. They've had to be innovative in the way they implement the Law of the Sea Convention. And thanks to the of be able to do that, then the Pacific Island countries were able to capture a greater share of the benefits through regionalism. And I don't think, I think 40 years on, in hindsight, when we reflect on what the Law of the Sea Convention has meant, I don't think we would have been able to be where we are today without the instruments, the collaborative effort, and the work that the countries in the Pacific Island countries have done to implement and get the benefits. It's true, as Neroni said, there are times when there is, we might assume that there's homogeneity in the way in which we think and operate, and there are differences, but we are always willing as Pacific Islanders, and I think it's a cultural thing, and we're always willing at the end of the day, in spite of our differences, to be able to work together. And so it's actually reflected in many of the innovative measures that have been developed by the region that have international repercussions. The development of this regional register, for example, was an innovative mechanism to apply non-physical enforcement mechanisms to the fisheries. Even the application of region-wide vessel monitoring system was innovative in itself. And also not forgetting that when there was the differences with the United States, the countries were able to come together and develop the very first multilateral access agreement to resolve those differences. So the countries have been able to successfully use the framework of the Law of the Sea Convention to settle disputes, but also always at the same time recognizing that there are economic benefits and gains that they are always looking to achieve. Now, I look at the establishment of the UN Fish Stocks Agreement itself. There was the development of that agreement and the effort. I personally witnessed the effort that Pacific Island countries made to contribute to the development of UN Fish Stocks Agreement, the coordination that was involved, largely because it's such an important, the LOSC Convention and the development of the UN Fish Stocks Agreement means so much to the Pacific Island countries. And I think we failed to, probably we should mention that maybe as an international treaty, the LOSC Treaty, LOSC Convention is perhaps the most important multilateral arrangement that has had and has the most transformative impact and influence on the political configuration, political and economic configuration of the Pacific Island countries. So the contribution that the Pacific Island countries have made, we would get together all the time and develop regional negotiating positions and strategies and meet with different countries and groupings to ensure that the interests of the Pacific Island countries we also recognize. And you find in the UN Fish Stocks Agreement, there's Article 25, and I know one of the listeners here is Blaise Komlangan, a good friend of ours from the FAO, who was very influential in getting Article 25, which is the special requirements of one of the key provisions that recognizes the assistance and the needs, the special needs of small island developing states in the conservation management of resources. So I would like to just, I don't have as, the rich contribution that Neroni has made, but I think when I look at where we are today in terms of the economic benefits that now flow, the maturity that we have achieved in terms of the enforcement framework, the role that the FFA plays, the other institutions that we have, the Western and Central Pacific Fisheries Commission, based in Ponape. These institutions all reflect the efforts of Pacific Island countries to not only implement the LOSC Convention, but also to actually ensure that their resources are protected. Of course, within this framework, there are ongoing challenges that they face, but we are able to address them through the framework of the LOSC Convention. Part 5 in particular, for me, has been the most transformative. Of course, international fisheries now is becoming a bit more complicated. And but one thing that holds us in the Pacific Island countries together is a point that Neroni made. And I like to think that there's a cultural uniqueness about us in the Pacific Islands that binds us as the region. Notwithstanding all the things that the challenges and differences that we face, there is this respect, deep respect that we have for each other, and our deep respect to make sure that we help also each other. So that would be my take, Camille. Thank you very much.
That's really true, and a great observation, and also really important, the emphasis that you both have placed on the link between law of the sea and the Sustainable Development Agenda, and then the way that some of those issues, as you mentioned there, the needs of small island developing states have been played out specifically through the Fish Stocks Agreement. I think you're right, we perhaps underestimate the importance of that, the role that that's played. So I'm going to move back to Judge Slade to ask another question. And this time around, I really want to talk about the key challenges and opportunities that you all see in the Pacific under, within, and perhaps beyond the Law of the Sea Convention. Judge, in 2012, you were appointed as the inaugural Pacific Ocean Commissioner, responsible for spearheading the Pacific Oceanscape Initiative, a key part of which relates to the establishment of formal maritime boundaries in the Pacific. I wondered if you might reflect on some of the key challenges and opportunities for the Pacific as you encountered them in your role as Pacific Ocean Commissioner.
Thank you. That, of course, was a little while ago, and I will have to confess that I've not been able to keep up with the work of the Pacific Ocean Commissioner, and I cannot claim that I'm in any way up to date. But there is no question of the need and the importance of the office and the responsibilities assigned and expected of the office. Unless there have been dramatic changes in dedicated professional services and staff support, for example, it is by its nature a high-level coordinating and advocacy role. That's what I was expected to do. As to challenges, make no mistake about it, there are huge challenges confronting the Pacific Islands ocean region. Pollution, habitat destruction, natural and created hazards, marine boundaries problems, and so on. And as you know, specialist regional organizations have been established and developed to deal with a multitude of technical, scientific, and other details. FFA, SBC, SPREP, and of course, all these organizations have to rely on technical matters because of their special links to FAO and the meteorological organization of the United Nations, UNDP, etc. These regional organizations we have in the Pacific need to be clear, to be effective and transparent in their work, relationships, and cooperation with each other, and with the United Nations and other international services, indeed with partnership interests and operators in the private sector and civil society. The role of the Ocean Commissioner in the effective oversight and coordination of all this is, in my view, critical, more particularly with respect to significant challenges we are now facing. And I think, Madam Facilitator, your next question will point us to the serious problem of preserving maritime zones in the face of sea level rise. The Ocean Commissioner's role in the formulation of regional policy and responses, and his or her advocacy at the highest levels, regionally and on work relating to the oceans within the United Nations system. And as we have seen in the recent Oceans Conference in Palau, an important one, and many countries and many good Pacific-related issues are being raised there. Now, the expression of agreed Pacific positions and plans through the Ocean Commissioner is an effective manner of putting forward our collective and agreed viewpoints in these various fora. Professor Aqorau and Dr. Tupou will know much more, but I believe that Pacific countries have been able to do a great deal of good work over the years. As a region, we have been one of the first in the world to develop a well thought out ocean policy, for example. And over time, we have worked through regional ocean frameworks and integrated strategic action plans. There have been several of these, dealing with emerging threats of climate change and other threats, and also dealing with the essential aspects of leadership, technical and political, and with the dissemination of information, learning and teaching, and getting civil society and community support for all this. Now, all these activities will require clarity in policy and methodology. We need to have trained and efficient staff. We need to develop effective partnerships of all types with governments, international organizations, with corporations, business communities, etc. Above all, we need sustainable funding, not just for project funding or event funding, but funding can be reliable and sustainable for long terms. And above all, we need to have clear plans for review, for accountability, and plans for carrying things out, plans for implementation with clear targets, and so on. And through the Office of the Ocean Commissioner, we need, and we know this from Pacific experience, we need effective coordination and more of it. Now, the problem, of course, at the moment, I don't know, but it would be rather unfair and difficult to look at the Office of the Ocean Commissioner, which is only a double office to the Secretary General, or being the Secretary General of the Forum. Now, whether he has that capacity to do this, it would not be workable and may not be entirely fair to expect all this from the office in its present arrangements and so on. But these are the problems amongst the many problems, I think. So in terms of your question, are there challenges? You can take it from me. Yes, serious and tons of it. Are there opportunities? Endless opportunities. Endless opportunities for countries, economy, for communities, for the region as a whole. Endless opportunities. Thank you.
Well, thank you. And speaking of those opportunities and also of the importance of planning and coordinating, and you brought us a little bit to this already, but I wanted to ask about the 2021 PIF Declaration on preserving maritime zones that was issued last year. That declaration's already stimulated active discussion on these issues in academic and in government circles well outside the Pacific, from the Caribbean to the United Kingdom. So I wondered, perhaps briefly, what your thoughts and effects might be about the impact of this declaration and what it tells us about the role that the Pacific can play and is playing in facing these challenges and taking these opportunities in significant law of the sea issues.
I'm exceedingly impressed and very happy that the leaders have taken this step. The science is beyond clear, and the dangers of climate change, sea level rise in particular, has been known for a long time. Pacific concerns over climate impacts are a long-standing matter on the public record, clear, long-standing. Sea level rise and the consequences for maritime zones as such were not anticipated and not explicitly dealt with under UNCLOS. We will have to resort to general principles. I seem to remember myself that around 2010, perhaps earlier, Pacific leaders were committed to preserving forum countries' existing rights stemming from maritime zones in the face of sea level rise. Leaders have now issued this declaration, obviously a matter of seriousness and importance at that high political level, and given the projected effects of sea level incursions, especially on small and low-lying countries. The declaration, and I think it's clear from its terms, is firmly grounded in the primacy of UNCLOS as the enduring legal order for the oceans. The contention of leaders is that the principles of legal stability, security, certainty, and predictability underpin the convention, as do the principles of equity, fairness, and justice. Now, all of these principles control the application of the convention in the context of sea level rise and climate change. As laid out in the convention, in the declaration, the view of leaders is that once established in accordance with the convention, and I think we can take it very clearly that countries alone and the regional process for delimitation have proceeded on the basis of the convention. So once established in accordance with the convention, maritime boundaries and entitlements arising do exist and remain permanent and not challengeable or reducible because of sea level rise. That seems to be the fundamental position of leaders and of our region. And furthermore, Pacific countries have no course to review and do not intend to review and update baselines and the outer limits of maritime zones as a consequence of climate change related sea level rise. This, as you have noted, Madam Facilitator, has been the subject of extensive discussions and submissions before the General Assembly 6 Committee and before the study group of the International Law Commission. It seems that the topic of sea level rise in relation to international law has now been accepted in the Commission's work program, and I, for one, am very happy about this. I must say that one has been very impressed by the response from the Pacific member countries and by the Pacific missions in New York, and by the range and quality of their submissions and commentaries on the matter, including the submissions from the Forum Secretariat Oceans Commissioner, which is good. And I tell you, he is useful on behalf of member countries. I'm also sure we can all be very pleased that with Dr. Penny Ridings now on the Commission, we will have a renowned Pacific law of the sea specialist right in the middle of all this. Speaking personally, I fully support the declaration of forum leaders and the supportive views expressed by all of Pacific member countries. I will have to say that this is not the first time that forum countries have taken a stand on principles underpinning UNCLOS. As a region, we did so, as I have noted, in respect of the establishment of the FFA in 1979 in defense of Pacific rights and entitlements, and in accordance with what we regarded as established principles of international law and the Charter of the United Nations, and at that time, well before the conclusion of UNCLOS. Thank you very much.
Thank you very much. That was a fantastic set of insights into that declaration. I'm sure there's people scribbling furiously and also thinking, thank goodness I can rewatch the video of this later and listen to that again. I want to preserve some time to go to Manu, but I do have another question for Professor Aqorau, and it again goes to this idea of where we are now and the challenges and opportunities for the Pacific. And Professor Aqorau, I wondered if you'd be able to make any comments. You've seen the Law of the Sea Convention from all sides. You've worked in government, regional, sub-regional organisations, as a consultant, as an academic, and not only with the Law of the Sea Convention, but the Fish Stocks Agreement, the WCPFC, numerous other international and regional agreements. So with all that in mind, from a Pacific fisheries perspective, do you think this legal framework is still sufficient to meet the needs of the Pacific after 40 years? And is it flexible enough and robust enough, I suppose in particular, to enable the critical tuna fisheries of the Pacific to be managed successfully in the changing climate that we face?
I was just saying that I still believe, and I do believe, and I strongly believe, that the framework around which we are managing our fisheries that are provided in Part 5 of the Convention continues to be robust, not just now, but I think into the future. Mm-hmm. And we are so fortunate that we've been able to leverage that. Mm-hmm. The real challenge that I'm finding is that not all of Pacific Island countries share the same level of economic benefits from the resource. You're finding that the the grouping of countries known as the PNA are probably enjoying far greater economic benefits than the non-PNA. And so that is where our challenge lies, to ensure that for the other tuna species, that there are also similar kind of gains that we can use by leveraging the LOSC Convention, the Fish Stocks Agreement, and the Western Central Pacific. I think climate change is going to have an influence in the way in which the productivity of zones and therefore the economic benefits will have, but that's not going to change the basic framework of the convention. It has served us really, really well, and I think it will continue to serve us well into the future. The other opportunity, as Neroni said, the real opportunity is to use those provisions and be innovative, continue to innovate and continue to be smart about the way we manage our resources. Technology is improving, and more importantly, we have to be building capacity to train and the next generation of future fisheries leaders who can build on the gains that we have developed now and continue to innovate. So I'm pretty optimistic. We've got very strong regional institutions. And as I always said, you know, there might be disharmony at few moments in time in our relationships between the island countries, but the depth of understanding and the depth of feeling that we have for each other is that we want a Pacific Island region that does well. And I think that is what will drive the region. So I'm loath to see any real changes in the convention. We're so lucky, I think, for the people like Neroni and Satendra Nandan and those who negotiated the fisheries provisions, and we should be grateful. And I would like to take this opportunity to thank all of you listening who helped me a lot when I was stages of my career in foreign affairs. Thank you very much to all these people to make us where we are today. Thank you.
Thank you, Professor. And I think you've just demonstrated there in a very real way the central focus of people in all of this and the respect, the culture of respect that you talked about earlier. It's great to have such a positive reflection on that, particularly when so much of us as academics spend our time criticising the framework. It's really nice to hear it spoken about in that way. Now, I do want to come back to Dr. Manu, who is with us, and perhaps we'll speak with her camera off. I did have a second question for her. So my first question for her was around the influence that the Pacific might have beyond the region in terms of perhaps being used as a template for some of its innovations. And the second question I was going to add on was really sort of specifically drawing that out in the context of enforcement of coastal state laws and regulations, where Pacific Island countries have developed a really robust and innovative framework. And I was wondering what she thinks has enabled the Pacific to be so successful in this area, and key challenges and opportunities for the future. So I'll present that as an open-ended question in relation to which she can say anything she likes, since I interrupted her so much before. So Manu, over to you.
Thank you very much, Dr. Camille, and hopefully you can hear me better this time. Appreciate the opportunity for FFA, and I'm going to cover both questions because I think that they're just fantastic questions to showcase the work of our membership and our Pacific people. It's truly humbling. I'm going to repeat this at the outset. I don't want it to be missed. It is really humbling to be invited to join my esteemed co-panelists in this eminent forum, Judge Neroni Slade, who's so well known in our region. And I agree with Professor Transform. We could listen to him all night. And also Professor Transform Aqorau, who I had the privilege to come into FFA as a legal officer under his leadership. And what it reminds us, Dr. Camille and all colleagues on this call, is that we stand on the shoulders of these giants that have come before us and really paved the way. Our leaders who had the vision to direct our full and active participation in the UNCLOS conferences, our negotiators such as Judge Neroni Slade, and the continued expertise of so many today, such as Professor Transform. You've highlighted in the first question about our Pacific approaches and how it's been successful, how it's influenced the way that we've implemented the Law of the Sea Convention. And I'm going to highlight 3 points here, Dr. Camille. One is the reality of what we're dealing with. The ocean is 96% of our region. So it's central to our lives, our livelihoods, our economies, and indeed it's our lifeline. And this is the reality for our Pacific peoples, and that has framed our relationship with our ocean and has framed the way that we negotiate in all matters related to the ocean and the law of the sea. The second point I'd like to make, and has already been stated by my esteemed co-panelists, in terms of the power of our cooperation. The repeated stance of our negotiators, for example, to successfully put across our key positions, especially in UNCLOS III, and including our matters of key importance, such as the establishment of the exclusive economic zone and the recognition of our sovereign rights, which was referred to by Judge Slade and Professor Aqorau. That, from a fisheries perspective and the extension of our coastal state maritime jurisdiction, was a huge achievement for our developing states, especially within the membership, and with the push from the entire membership and staying together. So that real importance and value of our cooperation. And you've highlighted as well earlier the leadership in the region, not just with UNCLOS, but also through the Drift Nets Convention and ensuring the global ban on drift nets. There is a lot to say and examples to point to, but I think the important point there about the Pacific approach and that importance of cooperation is the second point. The third point, and you highlighted it just now and referred to also by my co-panelists, and that's our people and keeping them in front of mind in everything that we do. And I think that's what really drives our work. And you know, I'm extremely proud of the continued leadership in our region today, which ensures that our region is the only one in the world where the major tuna stocks are biologically healthy, where we continue to receive over $500 million to government revenue in the form of access fees and over $900 million worth of tuna exported from our members, particularly in the percent fishery. And your point about where we can serve as a template for other regions, I think that all of these matters I've highlighted can offer standards that could serve as a template. The robust fisheries management measures that have ensured the sustainability of our stocks put in place by our membership. And I reiterate here what Dr. Aqorau referred to, the particular leadership of the parties to the Nauru Agreement, the PNA, whose office had the benefit of Professor Transform Aqorau as their inaugural head of office, and the Vessel Day scheme that they've put together collectively to assist with that. Apologies, I've got kids in quarantine with me, so I apologize for that. So that's one. And the other standard that serves as a template refers to the integrated MCS framework that has been established by our members over 40 plus years. And that's something that I'll highlight given your second question. The Maritime Boundaries Normative Declaration by leaders to preserve our boundaries, as has been alluded to by Judge Slade. The normative declaration adopted by our leaders is a visionary instrument that not only preserves those formalized maritime boundaries, but also within our zones, it safeguards the rights, duties, and jurisdiction of our Pacific states over our tuna fisheries. Then going to your last question about enforcement initiatives and what we think has enabled the Pacific to be so successful in this area, and key challenges and opportunities, everything I've spoken to in terms of our Pacific approach, the recognition of the centrality of our ocean, the importance of our cooperation, always remembering why we do what we do, why we must work together, our fisheries, our people, our future. And, you know, in terms of the challenges, Professor Aqorau referred to climate change. There's also the unregulated fishing and management of longline fishing that's happening especially on the high seas by longliners that needs to be reined in and addressed, and that's something that is a priority for our membership. And I'll highlight here, given your question, the challenge of combating IUU fishing. We had an IUU quantification study a few years ago that provided two key findings. One that estimated over $650 million worth of fish caught or harvested illegally in our region. This has recently been updated through better metrics to halve that number, which we're really pleased about, and it also shows that our tools are working. The other important finding, which continues to today to the update, is that our challenge is not dark targets or vessels that are unauthorized to fish. Our key challenge are our own licensed vessels and ensuring that the types of mechanisms we put in place, our robust MCS integrated framework, monitoring, control, and surveillance, that we're not complacent, and that we continue to find those innovative ways highlighted by Professor Aqorau to ensure that we can safeguard this valuable resource. I'm going to stop there, Dr. Camille. I know that time is of essence to the meeting. Happy to answer any questions. Thank you.
Thank you, Dr. Manu. Time is of the essence, but also the essence is of hearing what you all have to say. And thank you so much for that. I think all of the contributions have really reinforced and spoken to each other, which is so important in a discussion when you're being asked one question at a time. But I think some things that keep coming out to me over and over are the perspectives that you've all given us, perspectives in terms of size of the sea, size of the island, size of population, size of delegation, size of contribution. There's all different ways we can measure size, but I think the perspectives that you've brought us to in those different ways is really important. The second one is people, and I like the way that you brought out there, and this was always the case for me in working with FFA, the very clear sense that people are at the front of mind always, and that's come through everybody's comments at all levels. And then thirdly, this idea that Judge Slade mentioned about sort of limitless challenges and opportunities, that all of these things seem to reinforce each other and actually seem very positive and optimistic to me. So thank you very much. I'm going to ask our audience if they would like to ask any questions. I wanted to take us right back to the beginning, I'm afraid, and ask Judge Slade. And this is a question that we dwelt on a little bit in our previous seminar on Australian and New Zealand perspectives. Just thinking about UNCLOS III as a process, whether there are any particular lessons that you think Pacific Island countries might usefully take from the UNCLOS III experience in terms of approaching future lawmaking exercises, whether through the UN or elsewhere.
There's very little to compare the law of the sea process to, other than to try to accept the fact that it is a holistic approach to a subject that is ever present, almost everywhere in the world. And for us in the Pacific is total, it's encompassing, it is there. It is intellectually impossible to seek to understand the oceans in which we live. I think the wonderful achievement of UNCLOS, it has been focused on essential principles, but these are very large and in a way general principles. Now we have to read, we cannot understand, there cannot be validity in UNCLOS taken alone. It needs to be read and understood as against part of the law of the United Nations Charter, for example. It needs to be understood against the special General Assembly requirement, or what is it, Article 11. and against the separate agreement on fish stocks agreement. But also it has to be understood in a much broader basis now, as we begin to understand the planetary issues like climate change and try to deal with it. So I think your question is a difficult one. And, you know, one could say quickly, I have considerable experience of negotiating climate change. You know, and you could look at that as pure models, but what does it mean? You know, both are very, you know, these are difficult processes, and I think we simply have to try to deal with it. I think it's best. I'm one of these people who would not rush into reviewing UNCLOS. I think we've made a wonderful, wonderful achievement. Let's work at it, keep working at it. And I thoroughly, fully agree with Professor Aqorau on that. I think it's been a wonderful deal with it. And so often it's not the law, it's not the principle, it's what we make of it, surely. And it cannot be the principle that tells us what we need to do to preserve our fish and to be sensible about it, feed ourselves, but in order to do that, preserve it. And we cannot, fish do not live alone and exist by themselves. They have to live by the environment, and we have to do both. So I think it's a little difficult from your question, although one thing I do believe that we've done correctly as an international community is to take a holistic approach, which is realistic, it's humane, it's necessary. I think it's environmentally visionary. And yet we do know that the environment in our oceans is seriously depleted, very badly polluted, and in many, many respects, including in the Pacific, is under distress. And some of us are beginning to work at an ecologically necessary level, and to think of the oceans as amongst one of these so degraded areas that there is the possibility of the ocean being offended to by human activity. So there you are. I'm trying to duck your question, I suppose, but I find it difficult to answer your question.
That's okay. That's a difficult one to be asked off the cuff as well. So thank you. It sounds again like a lot of challenges and opportunities there. I see that our colleague Blaise Komlangen from the FAO, who's already been remarked upon tonight for his role in negotiating in the fish stocks agreement, has his hand up. Blaise, would you like to pose a question?
Thank you, Dr. Camille, for this seminar and to the organizers for pulling together such a distinguished panel in the form of Judge Slade and my good friends, Professor Aqorau and Dr. Tupou. Really a pleasure to be here, and I can only agree with many of the things they have said, in particular in relation to the contributions and advances in international law, and certainly attributing those to us being able to stand on the shoulders of giants, Judge Slade included, Satya Nandan, Devita Tupou, Peter Doneghi, Philip Muller, and others. And the fact that they draw all these from the inherent characteristics of Pacific peoples, namely respect for elders and wisdom, not just individual, but collective wisdom, diplomacy and gentleness, and the predisposition and wisdom and preference for consensus and compromise. I was just thinking that another characteristic of Pacific peoples is the ability to convey raw facts and emotions using God-given oratory skills and merely speaking from the heart or from the gut, as many of Pacific Island languages would have you say. And the fact that those of us who learned from this and were wise to align Pacific Island countries with the UNCLOS regime of the islands, the EEZ, and the archipelagic states, I think draw from this ability to convey raw emotions and based on facts. And I see this also going through to the discussions in the UN FISTOPS agreement on the special requirements on developing states, the specific interest that you must have if you want to cooperate and be part of a regional fisheries management organization. And even now, as we see in the BBNJ negotiations and the declaration of preservation of maritime boundaries and maritime claims, I would like to ask if this resonates with the panel, and whether they could add to this particular characteristic of Pacific peoples.
Thanks for those observations, Blaise. That was great. I'll go just to each of our panelists to see if they want to comment or respond or add to that. I'll go to Judge Slade first, and then Professor Aqorau, and then Manu. Just on mute, Judge. We'll get it.
No, first of all, let me express my absolute delight in pleasure in seeing Blaise again. We had missed him terribly when he moved to FAO. We thought we had lost him, but in fact, it had been a wonderful Pacific investment for Blaise to move to FAO. And he's just been an invaluable link between our region and the FAO on these matters. He's just one of the most knowledgeable, articulate, and deep thinker on these matters. So with great admiration, I welcome his presence at this session. I cannot answer his question better to say that I agree with him, with everything that he said. And I think he's the one that personifies these questions, these characteristics that he has touched on. And I think this is the qualities of our people. They are noticeable when we go into international fora. We have no issues with other people or other countries. We seek to project our image. Our claims are not excessive. Our claims are natural. We believe they are dictated by need and by equity considerations. And on so many areas where there are economic issues, as in the oceans, where there are security issues, as in climate change and biodiversity, I think we bring to the international debate on many of these critical issues, not only fearless intelligence and our ability to protect and to stick up for principles, but I think for me, the need for Pacific involvement in so many of these issues is that they have the gift to contribute to international dialogue, a special ethical dimension, human concern for our natural environment, and for simple justice. Thank you, Blaise. Good to see you on screen. Thank you.
That's beautiful. Thanks, Judge. That's a lovely concluding observation from you as well. Transform, would you like to make a comment or add anything as a sort of concluding observation?
I would like to join Judge Slade in also thanking Blaise. It's nice to see you, Blaise. Blaise and I were classmates in Papua New Guinea, so it's gives me great pride to see his way he is and his contribution. There's a couple of things for me that really stand out and has helped us shape these things. One is our personal relationships and friendships. That's one thing I learned when I came in and I saw how Philip Muller and others they managed and harnessed these wonderful, there was a lot of serious discussions going on, but there was a lot of social singing, kava, and this is where a lot of the discussions also took place, and a lot of, in fact, agreements were reached around outside of the meetings rooms, very much in the nature of Pacific Islands. And I can assure you that one of the great strengths, and I just hope that COVID passes so that our people can start to meet each other again, is that these friendships and relationships that people have with each other actually have some of the most biggest influences in helping to reach agreement. You only have to wink your eye to your colleague from Samoa or from Tonga across the table, and they will and they will know what you mean and understand. And so that to me has been a great influencing factor in the region, in the way in which we've shaped. I think of even the PNA, it might look like it was a breakaway at the time, but its formation was based on friendship amongst the officials and the ministers. I don't think that if we had a different grouping of ministers, we would have been able to get those agreements that we did at that time. But I emphasize that it was friendships, and I think they've reached out to the my vision was that we would build on the success of this little group for the wider group to reach out, and I hope that, and that's why I made the point that there is the PNA have benefited economically from, and I would like to see the rest of the Pacific Island countries enjoy the same kind of benefits from the Vessel Day scheme that the PNA enjoys. So personal relationships are just so important. That's what I learned right from when I started off, and I was fortunate, I said, to have Philip Muller as my boss and my mentor. So I saw the value of these relationships in institutional development in the region. I just hope that our people in the region will continue to maintain that. And I think they will, because we are people of the oceans. We have a deep respect for each other, in spite of those differences that you read and all those things that you see about the appointments and whatever. But Pacific Island countries, peoples will always find a way to help their people. So that would be my parting contribution, and thank you, Blaise, for that question.
Thank you, Professor. In a minute, I'm going to hand back to Professor Rothwell, but Manu, you get the last word if you have any final comments or observations.
Thank you very much, Dr. Camille. And I think that Judge Slade and Professor Aqorau have really aptly responded to Blaise's question. And can I say, Dr. Camille, we're certainly seeing all the great Pacific Law of the Sea experts here. It is so wonderful always to see Blaise and to learn from him. I continue to learn from him. I started very early at FAO as a junior under his expertise, and as Judge Slade said, he's a wealth of knowledge in our Pacific work and also internationally. And Blaise, the comment you made certainly resonates with us. sheer ability of our Pacific peoples to convey our positions and speaking from the heart. That we've seen some of the finest speeches or statements made in our meetings, from off the cuff comments that haven't been pre-prepared, that fully articulate the issue and the positions from our Pacific countries so well that no one could have written that up. And it's truly coming from a really great place, and it's the Pacific heart, and it's in our work, it's in our relationship with our ocean, as highlighted earlier. It's in our firm belief that only by working together and speaking up that we're able to achieve the successes that our people have done so far. Also, the comment that Professor Aqorau made about relationships, that is central as well to getting our work done, and he has highlighted that so well. So I've got nothing else to add here, but a huge thank you for this opportunity for FFA to share alongside these massive experts, and to continue to learn from them and from you, Dr. Camille, Professor Rothwell. And every time that we get this opportunity or platform to talk about the law of the sea, there's something new for everyone. Thank you.
Thank you, Dr. Manu, and I apologise to everyone for taking us over time, but I was just too reluctant to cut any of those contributions short. They were wonderful, they were heartfelt, they demonstrated the things they were talking about with great insight and expertise at the same time. So thank you all very much for those wonderful contributions, and I will pass now back to the chair, Professor Rothwell.
And can I add my thanks to Camille's for our speakers this evening. We've received an incredibly rich array of observations, reflections, and insights in terms of the law of the sea in the Pacific, which was the intention of this webinar. And I think it just perfectly complements our first webinar from February, where we looked at those issues very much from an Australian, New Zealand perspective. Colleagues, our next session in this webinar series will in fact see Professor Tommy Coe speaking to the Australian New Zealand Society of International Law Conference. I'm advised by the President that discussion with Tommy Coe will take place on the 1st of July. We'll make sure that we advise all of you of that particular event and how you can participate in that event. And then we will be following up with further webinar sessions in August on looking at UNCLOS III and institutions. And then in October, looking at UNCLOS and dispute settlement under the Law of the Sea Convention. So can I just conclude by thanking all of you once again for participating. Thank our speakers very much. Thanks everyone for their perseverance during our technical issues, but I think we all soldiered through. I've just lost some power here in Canberra and it's gone all dark for me. So I think it's a good time to say good night and have a good evening, everyone. Bye now.